ICSI IIT, that is Final Word on IBC. Today we have with us two faculties, Mr. Ankit Goel and Mr. Nilesh Sharma. We shall discuss two Supreme Court cases today, Maitreya Doshi versus Anand Rathi Global Finance Limited and others, and Balkrishna Rama Tarle versus Phoenix ARC Private Limited and others. The first session will be taken by Mr. Ankit Goel. Let me provide you a brief introduction of Mr. Ankit Goel. Mr. Ankit Goel is a chartered accountant, registered valuer, and an insolvency professional. He is a founder partner of AAA Valuation Professionals LLP, AAA Insolvency Professionals LLP. He is a managing partner of AAAG and Company LLP, Chartered Accountants, and a director in AAA Capital Services Private Limited. Mr. Ankit Goel is a regular speaker for insolvency, valuation, and forensic subjects at various forums. Sir, you may now start the session.
Thank you so much. Thank you, and good evening.
Sir, you are on mute.
I am no longer on mute. I think I should be audible now.
Sir, you are on mute.
Yeah, he is audible. We are able to listen him.
Yeah. So I think Anu will have to check her speaker. I think I'm audible to everyone else. I am unmuted. So thank you, Anu. Thank you for the introduction, and good afternoon, everyone. And we have two very, very important judgments which are part of our detailed discussion, our agenda today. Both these judgments are from the Supreme Court, Honorable Supreme Court of India. And yes, judgments from Supreme Court of India are very, very important. And the recent circular or notification or circular from IBBI, which now requires insolvency professionals to inform IBBI on any matters with respect to the cases where insolvency professionals are appointed as RPs, IRPs, liquidators, etc., which are pending with the High Court or with any High Court or Supreme Court. IBBI wants the IP to inform IBBI about those cases, pending cases. The idea is to avoid any judgments coming in from these high courts, which affect the entire IBC law or the interpretation of that law, and make sure that IBBI is able to represent, or the government is able to represent in the courts on these judgments. So the recent judgment of Vidarbha Industries was one judgment which caused a lot of stress in the insolvency arena. A few judgments were also passed in NCLT or NCLAT based on the Vidarbha judgment, holding that the default is not the only cause for insolvency to get triggered. In that case, Supreme Court rather distinguished and said that this case, the case that was at hand at that time, was pending, or the payments were pending because of pending arbitral award, which was pending in appeal before the Supreme Court itself. The award was already granted, but it was pending with the Supreme Court of India. But yes, certain comments which were passed in that order in the Vidarbha judgment were then observed by IBC as difficult to be. Then those interpretations, if carried on or used by at other forums, would disturb the IBC process or delay the IBC process. So in the review petition filed recently, then of course the court has said that no, those remarks are specific to that case. So therefore, we need to understand the importance of these judgments, and also how these judgments can play a large role in how the interpretations happen. The other judgment of the Supreme Court, when the matter of sales tax officer versus rainbow paper, that's also a very, very interesting judgment, where where again it is we are assuming that there will be some clarity which will come in after some point in time. So I will skip to the judgment where we are of course discussing these two judgments today, and Maitreya Doshi will be taken up by the other speaker, Balakrishna Rama Tarle and versus Phoenix ARC. These are the ones that I will take up. Let me just try and come to the page which is the relevant page. Just hold on. Yeah. So I hope you can all see my screen. And Balakrishna Rama Tarle. So basically, this case is the facts of the case involve that how Religare Finvest sanctioned a loan of ₹6 crores in favor of the borrowers, and the said loan was secured by a registered mortgage created by borrowers in favor of Religare in respect of the property secured assets. Borrowers committed defaults in repayment of said loan, which led to Religare classifying borrowers' account as NPA. Then Religare issued a notice under Section 13(2) of SARFAESI Act, calling upon borrowers to pay the amount then outstanding under the said facility, and by deed of assignment, Religare assigned all its rights, title, interest, and benefit under the said loan agreement to the first respondent, that is Phoenix ARC. Then original petition, that was the original petitioner before the High Court. Thus, first respondent stepped into the shoes of Religare and became the secured creditor, and in that capacity issued a notice under Section 13(2) of SARFAESI Act. The secured creditor took symbolic possession of the secured assets under Section 13(4) of SARFAESI Act. Then thereafter, the secured creditors filed an application under Section 14 of SARFAESI Act seeking assistance of district magistrate for taking physical possession of secured assets. Those of you who are not very well versed with SARFAESI Act, you would know that I would like to say that Section 14 of the SARFAESI Act is an important section. It provides for how the local administration the support of the local administration can be applied for by the banks who are taking action against a mortgaged asset under SARFAESI Act. The authority declined to assist the secured creditor in taking possession of the secured assets and kept the said application pending by observing that after termination of the tenancy rights of petitioner by finance company, by following due procedure of law, the further orders regarding possession of the mortgage property will be decided. So the DRT simply said that we will take up this application only after tenancy rights or termination of the tenancy rights of the petitioner by the finance company. So there was a tenancy right on the property. Now, to ask all of you before we proceed forward, how does tenancy of a property or tenancy in a property change the value of the property or change the rights of the landowner? Anyone who has experienced this or who understand this tenancy rights, maybe you can just unmute yourself and share your
Sir, tenancy right will depreciate or value reduction will be very high, at least in the city of Bombay. If I have a property where tenant is sitting, I may not realize even 40-50% of that.
So the tenancy right, if there is, it depends. So you're saying that
this is my thinking.
So you're saying that the tenancy rights in a city like Bombay will decrease the value of the property. That is a possibility. I'm sure of that. Tenancy rights can also increase the value of the property. I will tell you how. But my question is that what is the nature of a tenancy right? Is a tenancy right something which like when we say that there is an ownership of a property where the owner has possession and the owner has title of the property. Now, when we say that the owner has title of the property, but the possession is with the tenant and there is a tenancy right on the property, in that situation, what do you think happens to the tenancy right at the occasion of maybe insolvency starting up or SARFAESI proceedings starting up? How is the tenancy affected?
So there are basically two type of. One is the tenancy under where he is a permanent as good as permanent occupant, and second is leave and license basis where he has to vacate within the 5 years.
I'm talking about tenancy, sir. I'm not talking about leave and license. I understand other options where leave and license is the right to use the property and it is a little different from tenancy. I'm talking about tenancy with the way tenancy is there, like tenancy in proper tenancy, where we're talking about rent, we're talking about lease, we're talking about that only.
Yes.
So there, what is everyone's understanding that what is the nature of a tenancy? Does it cease to exist on SARFAESI coming in, or it does not cease to exist, or after IBC coming in, does a tenancy cease to exist? My second question is that in case there is a liquidation that happens for a company, what happens to the tenancy rights that the company has over some land and building assets? Anyone who
Interesting
can
question.
share their view.
Interesting question, but
We are not the right answer. We are looking at some answer. Some estimate on what should be the law or what should be the impact of law in this area.
it should be vacated. Otherwise, the purpose of liquidation will not be achieved.
It should be vacated. So I'm saying that the company or the CD had tenancy rights, and in that case, you're saying that the tenancy rights will automatically cease to exist the moment there is a liquidation.
Tenant CD is the owner of the property or senior.
In the example that I am taking, the CD is a tenant.
Tenant, then so if he is a tenant, then he.
No, sir, as per me, the tenancy will, go on as per the lease agreement or the arrangement, whatever they had with the CD. And also moratorium starts so that I know that process will continue. As per me, tenancy right will continue. As a liquidator or IRP processing person, I will take up the lease and proceed further. If it is not affecting the company in some way to run the business, then maybe I can shift it to the other address, but I still continue with the tenant address and continue to adhere to that.
Right. So you're saying that the tenancy is unaffected by the moratorium imposed by IBC or the liquidation process starting for a company.
Under liquidation not, but under the CRP process, the tenancy will continue. Otherwise, how can I maintain my going concern?
Yeah, my question was not about CIRP. Sir did mention CIRP there. So my question is with respect to liquidation only. I understand in a CIRP, the lease will continue or the tenancy rights will continue. Yeah.
Liquidation, then there is nothing like moratorium.
Yeah, sir, sorry. If it is a liquidation, then a tenancy right ceases, sir.
Tenancy rights cease in case it's a liquidation,
Yes,
where the
yes.
tenancy rights are towards me and I am the tenant. So there you're saying the tenancy rights cease to exist. Okay, and what about SARFAESI? What do you think happens in SARFAESI where the bank has a mortgage and now that the mortgage property is tenanted or there is a tenancy on that property which is mortgaged with the bank? What do the bank rights become superior or the tenancy rights become superior? Because the bank may not be able to take possession and sell the property where the tenant is already sitting and has possession of the property.
Normally, banks sell as is where is what is.
But legally, what will happen? Legally, tenancy will continue or not? So let's answer all these questions and let's see what the Supreme Court said in this regard. So we are saying that, of course, the termination of tenancy rights, and that is the observation based on which the DRT said, the DM said that I will not be able to assist you till this matter is cleared. Now, feeling aggrieved and dissatisfied with the order passed by the designated authority, the additional district magistrate, in not passing any order of assisting the secured creditor in taking possession of the secured assets and exercise of powers under Section 14 of SARFAESI Act, the secured creditor preferred writ petition before High Court. By the impugned judgment and order, the divisional bench of High Court set aside order dated 27/8/2021 passed by the designated authority additional director district magistrate by observing that such an order is beyond the scope and ambit of the powers to be exercised under Section 14 of SARFAESI Act. Then it says thereafter, the division bench of High Court directed the designated authority or additional district magistrate to hear and dispose of the application under Section 14 of SARFAESI Act in accordance with the provisions of Section 14 of the SARFAESI Act. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court, the third-party petitioners claiming to be tenant in some of these secured assets have preferred the present special leave petition. Now, the issue involved is whether during exercising powers under Section 14 of SARFAESI Act, the district magistrate designated authority can pass such order that unless and until the secured creditor terminates the tenancy rights of the third person by following due procedure of law and further orders regarding possession of the mortgage property, only then an application under Section 14 of SARFAESI Act will be decided. This was the question put before the Honorable Supreme Court. Now let's understand the relevant section. Section 14 of the SARFAESI Act is very important. Says Chief Metropolitan Magistrate or District Magistrate to assist secured creditor in taking possession of secured asset. So where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of this act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the CMM or the DM within whose jurisdiction any such secured asset or the other documents relating thereto may be situated or found, to take possession thereof, and the Chief Metropolitan Magistrate, or as the case may be, the DM, shall on such request being made to him, take possession of such asset and documents relating thereto, and forward such asset and documents to the secured creditor. Now there are some provisos. Proviso 1 is it says provided that any application by secured creditor shall be accompanied by affidavit duly affirmed by authorized officer. What all does the affidavit declare? It declares that the aggregate amount of financial assistance granted and total claim of the bank as on the date of filing the application, that will be mentioned in that affidavit. The borrower has created security interest over various properties, and that the bank or financial institution is holding a valid and subsisting security interest over such properties, and claim of the bank or financial institution is within the limitation period. Then the borrower has created security interest over various properties, giving the details of properties referred to in subclause 2 above. Then the borrower has committed default in repayment of financial assistance granted, aggregating the specified amount. Consequent upon such default in repayment of financial assistance, the amount of the borrower has been classified as a non-performing asset. Affirming that the period of 60 days notice, as required by provisions of subsection 2 of section 13, demanding payment of the defaulted financial assistance, has been served on the borrower. So this is how the proviso reads. Going further, then it says that the objection or representation reply to the notice, all these need to be taken care of. The borrower has not made any repayment of the financial assistance in spite of above notice, and the authorized officer is therefore entitled to take possession of the secured asset, that the provisions of the act and the rules made thereunder have been complied with. This is how the affidavit is read, and this is how it is structured. Then provided further that on receipt of the affidavit from authorized officer here is the authorized officer who is authorized to sign on behalf of the bank. The DM or the CMM, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured assets within a period of 30 days from the date of application. Provided also that if no order is passed by CMM or DM within the said period of 30 days for reasons beyond his control, he may, after recording reasons in writing for the same, pass the order within such further period, but not exceeding in aggregate 60 days. So this is how the proviso reads. Then provided also that the requirement of filing affidavit stated in first proviso shall not apply to proceeding pending before any DM or CMM, as the case may be on date of commencement of this act. So let's DM or CMM may authorize any officer subordinate to him to take possession of such assets and documents relating thereto, and to forward such assets and documents to the secured creditor. Then for the purpose of securing compliance with the provisions of subsection 1, the CMM or DM may take or cause to be taken such steps and use or cause to be used such force as may, in his opinion, be necessary. Then to no act of CMM or DM done in pursuance of the section shall be called in question in any court or before any authority. This is how the section reads. Then the contention of the petitioner here was that when petitioners claim to be the tenant of original landlord with respect to some of the secured assets of which the possession was sought, and when the original writ petitioner stepped into the shoes of the original landlord as rightly observed by the designated authority, additional DM, unless secured creditor who steps into the shoes of the original landlord initiates the legal proceedings for eviction of the tenant, cannot get possession in application under section 14 of the SARFAESI Act. Then high courts ought to have appreciated that the tenancy was subsisting and continuing since prior to the mortgage of the property, and therefore their rights are to be protected, and unless and until the proceedings are initiated or eviction of the tenant, the secured creditor who shall be in shoes of the original landlord cannot get the possession in an application under section 14 of the SARFAESI Act. CMM-DM to immediately move into action after this was the decision of this SC. So they were supposed to move into action immediately after receipt of written application under section 14 of the SARFAESI Act from the secured creditor for that purpose. Then it says as soon as application under section 14 is received, the CMM-DM is expected to pass an order after verification of compliance of all formalities by the secured creditor referred to in proviso in section 14(1) of SARFAESI Act, and after being satisfied in that regard, to take possession of the secured assets and documents relating thereto, and to forward the same to the secured creditor at the earliest opportunity. Then once all requirements under section 14 of SARFAESI Act are complied with, satisfied by secured creditor, it is the duty upon the CMM-DM to assist the secured creditor in obtaining the possession as well as documents relating to the secured assets, even with the help of any officer subordinate to him, with the help of an advocate appointed as advocate commissioner. So under the circumstances in the present case, no error has been committed by the High Court in setting aside the order dated 27/8/21 passed by the designated authority, keeping the application pending till the secured creditor initiates the legal proceedings for eviction of tenant cannot get the possession in application under section 14 of the SARFAESI Act. So let me repeat, under the circumstances in the present case, no error has been committed by the High Court in setting aside order dated 27/8/21 passed by designated authority, keeping the application pending till the secured creditor initiates the legal proceedings for eviction of the tenant cannot get possession in application under section 14 of the SARFAESI Act. So this is how this judgment reads. Now let me stop this sharing and also share with you the entire judgment, and let's spend some time on the entire judgment. So we have already talked about this. We have talked about Religer giving the 6 crores. So this is an important para which says that the petitioner placed reliance upon an order dated 24/2018 passed in regular civil suit number 58/2018 filed by him against one of the borrowers, whereby one of the borrowers was restrained from disposing him from the said premises. At this stage, it is required to be noted that neither the borrower nor the petitioner instituted any proceeding before DRT under section 17 of SARFAESI Act against the steps taken under section 13 of the SARFAESI Act. That thereafter, the designated authority passed the following order dated 27/8/2021 and declined to assist the secured creditor in taking possession of the secured asset and kept the application pending. So this is the part that we have read. And this is the order passed by them, that in consideration of the reasons recorded in the above referred issues, the claim the application of finance company to keep the decision is kept for decision. After termination of the tenancy rights of third person complainant, Sri Balakrishna Rama, and due procedure by following the due procedure of law, the possession, the further orders regarding possession of the mortgage property will be decided. In any party, if any party feel aggrieved due to order when they file an application under section 17 of Surface before Honorable Debts Recovery Tribunal, Mumbai. So no order as a cost. This is the order that was passed. Feeling aggrieved and dissatisfied with the order, so they Nashik, so they kind of pass the order of assisting the secured creditor in taking possession of the secured assets. So the secured creditor preferred writ petition before High Court. We've already talked about this. Let us proceed forward. So the division bench of High Court directed the designated authority, additional district magistrate, to hear and dispose of the application under section 14 of the SFEC Act. So High Court ought to have, what was the argument of the advocate of the petitioner, the tenants? He was saying that the High Court ought to have appreciated that the tenancy was subsisting and continuing since prior to the mortgage of the property, and therefore their rights are to be protected, and unless and until the proceedings are initiated for eviction of the tenant, the secured creditor who will be in shoe of original landlord cannot get the possession in application under section 14. Then the court said that we have heard the learned counsel appearing in behalf of the petitioners at length. At the outset, it is required to be noted that after initiation of proceedings and taking steps under section 13.2 and 13.4 of the Act, thereafter the secured creditor has approached the district magistrate by submitting an application under section 14 of the Surface Act, and has requested the DM or the ADM to assist the secured creditor in obtaining the possession of the secured asset. It is required to be noted that neither the original borrower nor even the petitioners who were claiming to be tenant or secured credit assets have initiated any proceeding before DRT, and the proceedings were before the DRT were section 14 of the Surface Act. In the said application under section 14 of the Surface Act, instead of passing any final order to assist the secured creditor in getting possession of the secured assets, and while keeping the said application, the ADM has passed an order that only after termination of the tenancy rights, by following due procedure of law, the further orders regarding possession of mortgage property, the said application shall be decided. So therefore order passed by additional district magistrate has been set aside by the High Court, which is the subject matter of the present special leave petition. So short question which is posed. So this is this question that has been repeated here, that that we have already discussed. So they have then reproduced the section 14, which we have also already gone through. And then we have, let me go to the next part. Then on a final reading of section 14, it appears that for taking possession of the secured assets in terms of section 14, the secured creditor is obliged to approach the DM by way of a written application requesting for taking possession of secured assets and documents. The statutory obligations enjoined upon the CMMDM is to immediately move into action after receipt of a written application under section 14(1) of the Surface Act. And going forward, as observed and held by the court in the case of NKGSB Cooperative Bank, the aforesaid act is a ministerial act. It cannot brook delay. Time is of the essence, and this is the spirit of the special enactment. in the recent decision in case of R.D. Jain and Company versus Capital First, this court had an occasion to consider the powers exercisable by DM or CMM under Section 14 after considering the object and purpose of Section 14 of SARFAESI Act and the scheme of the Act under Section 14. It is observed and held in para 9 to 7 to 9 as under that so far as the powers exercisable by DM and CMM under Section 14 are concerned, statement of objects and reasons for which SARFAESI Act has been enacted reads as under. Then it talks about the object here. Then at this stage, it says it is required to be noted that along with insertion of subsection 1A, a proviso has also been inserted, whereby secured creditor is now required to comply certain conditions and to disclose that by way of any an application accompanied by affidavit, the DM CMM can pass the order and use their powers. Thus, considering the scheme of SARFAESI Act, it is explicit and crystal clear that possession of the secured asset can be taken by secured creditor before confirmation of sale or of the secured asset, as well as post confirmation of the sale. For taking possession of the secured asset, it would be done by authorized officer of the bank, as noted in Section 9 of the Security Enforcement Rules. So thus, in view of the scheme of SARFAESI Act, more particularly Section 14 of SARFAESI Act and the nature of powers to be exercised by learned CMM, DM, the High Court in the above judgment and order has rightly observed and held that the power vested in the learned CMM, the learned district magistrate, is not by way of person designator. Thus, the powers accessible by CMM, DM under Section 14 of the SARFAESI Act are ministerial step, and Section 14 does not involve any procedure. Does not involve any adjudicatory procedure process qua. So points raised by borrower against the secured creditor taking possession of the secured assets. In that view of the matter, once all requirements under Section 14 of SARFAESI Act are complied with, satisfied by the creditor, it is really cast upon the CMM DM to assist the secured creditor in obtaining the possession as well as documents. So this is how they have then interpreted the section. Then they say that, and the agreed party to be relegated to raise objections in proceedings under Section 17 of SARFAESI Act. So before DRT, and under these circumstances in the present case, no error has been committed by High Court in setting aside the order dated 27/8/2021 passed by designated authority, keeping the application pending till the secured creditor facilitates the legal proceedings for eviction of the tenant cannot get the possession. So this is how they safeguarded it. Then they say, now so far as the reliance placed upon the decision of this court in the case of Harshad Govardhan Sundagar by the learned counsel appearing on behalf of the petitioner is concerned, the same shall not be applicable to the facts of the case on hand. What is observed by the court in the aforesaid case is DM CMM has to give a notice and opportunity of hearing to the person in possession of the secured assets claiming to be class 1 or 2. Lessee of mortgaged borrower, as well as to secure creditor consistent with principles of natural justice, and then take a decision in the said decision. It is not observed that DM CMM has to adjudicate the rights between the parties. Now, so far as the reliance placed upon decision of this court in the case of Vishal and Kalsaria by the learned counsel appearing on behalf of the petitioner is concerned, the said decision shall not be applicable to the fact of the case on hand. In the said decision, the question before the court was of conflict of claim under Maharashtra Rent Control Act and the provision of SARFAESI Act, and which law will prevail. So the second and ambitious ambit of the scope and ambit of powers to be exercised under Section 14 of SARFAESI Act were not directly in question before the court. Even as observed and held by this court in the aforesaid decision, a judgment cannot be interpreted and applied to facts stimulated by reading it as a statute. One cannot pick up words or sentences from a judgment to constitute that it is the ratio decidendi on the relevant aspects of the case. So in view of the above and 4 reasons stated above, we are of the opinion that High Court has not committed any error in passing the judgment and order directing the designated authority to dispose of the application under Section 14 of SARFAESI Act, and we are in complete agreement with the view taken by the High Court that the special leave petition stands dismissed. So this is how the whole agreement reads. I would like to take some questions. We still have about 15 minutes to cover up. So maybe some of you can raise some questions on what you feel about or what you think about, any suggestions that you might have with respect to this, the matter at hand. Anyone?
Sir, this means that the tenant continues to stay with the premises.
No, the High Court rather said the opposite. The High Court's decree has been upheld by the court. So the DM here was holding on to the permission to take physical possession or giving support for the session. And in the initial court stage, the development was that in the initial stage at the DRT stage, at the office of the DM, the status was that the DM in his order had said that I have the packet, or I have the authority to give you this possession right, and he said no, because he said there is a tenancy in the property. So therefore the question here was that if the property is tenanted, then can't DM help the borrower in going to court and getting that property possession back? So that was the question at hand, which the Supreme Court rather said the High Court was right, because what High Court did was the High Court said that that irrespective of the tenancy rights, the powers of the irrespective of the tenancy, the DM should have passed an order in approving this support. That was the idea. So it says that by the impugned judgment and order, the division bench of the High Court has set aside the order dated 27/8/21 passed by the designated authority ADM by observing that such an order is beyond the scope and ambit of the powers to be exercised under Section 14 of the SARFAESI Act. So one, they said that no, you have the powers. It comes within the scope and ambit of the powers to be exercised under Section 14 of the SARFAESI Act. Thereafter, the division bench of the High Court was directed to designate the designated authority or ADM to hear and dispose of the application under Section 14 of the SARFAESI Act in accordance with provisions of Section 14 of SARFAESI Act. So this is how they kind of, what the High Court said was that please dispose the application. You can't just say that no, you are not. We can't say that you are not capable to do this, or it is beyond your power. But for the DM to say, or the ADM to say that there is a tenancy on the property, I will not pass an order, was something that was observed by the High Court as beyond their mandate. All right.
So now how we correlate to the suppose liquidation. So tomorrow if the liquidation starts, and how we correlate to IBC. See, we are here practicing IBC. So
when we are looking at IBC, I will just dig out Section 17 for you and share with you what SARFAESI says about IBC. Just hold on, because Section 17 in SARFAESI deals with tenancies. I will also come to how it is needed to be taken care of in IBC.
So is your presentation completed?
Just a second, ma'am. I'm just sharing my screen again, showing a section which is relevant to tenancy.
Okay, sir.
So here is the section. This is 17.4a. 17.4a says that where any person in an application under subsection 1 claims any tenancy or leasehold rights upon the secured asset, the Debt Recovery Tribunal, after examining the facts of the case and evidence produced by the parties in relation to such claims, shall, for the purpose of enforcement of security interest, have the jurisdiction to examine whether the lease or tenancy has expired or stood determined, or is contrary to Section 65A of the Transfer of Property Act, or is contrary to terms of mortgage, or is created after the issuance of notice of default and demand by the bank under subsection 2 of section 13 of the Act, and the Debt Recovery Tribunal is satisfied that tenancy right or leasehold rights claimed in secured assets fall under the subclause A or subclause B or subclause C or D or I or clause I of clause 1, then notwithstanding anything to the contrary contained in any other law for the time being enforced, the Debt Recovery Tribunal may pass such order as it deems fit in accordance with the provisions of this Act. So the power to determine if the tenancy is legal or as per the law or is valid is with the DRT. Now, in case of a property which is, let's say, we pick an example where the asset of the CD, where the RP has now come in and stepped into the shoes of the management, that asset of that CD is under a tenancy, and the tenancy agreement comes to you, and the tenant says that this is my, he provides details of the tenancy with the CD. Now, when that happens, then there is first question that comes to the COC and to the RP is that where the tenancy is required to be continued. Where can the tenancy be required to be continued? Where there's a going concern and the factory is running on rented premises, and that is a tenancy where the CD is the tenant. Alternatively, it can be a scenario where the tenancy is for a godown. There can be a scenario where the tenancy is for maybe some other facilities. So the COC, the way it approves all the expenses during CRP period, including the salaries of people, etc., also then has to approve how the tenancy will be paid for and what would be the tenancy payments going forward on the premises. Where the tenancy is not continued, then it would be expected by the tenant, or it would be a reasonable expectation by the landlord, that the company, the CD, vacates the property and hands over the property back to the landlord. Now, in case of liquidation, what happens to the tenancy on liquidation or CARP would also depend on the clauses of the Tenancy Act, the rent deed. In case the lease deed talks about what would happen in what eventuality, and there is a provision that one of the parties or maybe the landlord will be able to terminate the lease during liquidation process, then that termination can happen due to that process. So wherever the tenancy exists on a property, it is common to say that the relationship of the tenant and the landlord is normally through the underlying asset, and therefore the underlying asset's rights is something that is affected, and the two people and the landlord and the tenant would have a relationship based on that equation.
I have just a small query on this. May I ask the question?
Please go ahead.
Yeah, the thing is, like, if the company has a lease property, the CD has a lease property, and it has installed its assets like plant and machine lying there in those lease properties, and we go for CIRP, we look for a resolution plan, and if that fails, if
So good evening, sir. Can I take your 5 minutes time? नहीं कभी कभी बिजी रहता है ना सर सवार
So let me try and answer that as far as I could understand that I think the question is with respect to there is a tenancy, the factory is leased, the plant and machinery of the CD is located at that plant. Now, in
Yeah.
normal circumstances, you would go ahead and say or tell the COC that this is the rental that is fixed with this landlord, and this is the rent deed based on which this amount is required to be paid, and not paying this amount would lead to possible termination of the tenancy under the lease deed. And although the moratorium is available to the CRP, but moratorium is subject to provision of essential services, or provision of moratorium is subject to compliance with whatever payments are required to be made during the CRP period. So where the payments are not made during the CRP period, there can be litigation which might lead to requirement to vacate the premises which are occupied by the CD, where the rent is not being paid. So the COC in that circumstance will have to compare between two options. One option is to provide for payment of that rent, optionally provide for removal of the plant and machinery from that premises and giving the possession back to the landlord. These are the only two options that, in my opinion, will be available to the COC, and they have to decide between the two.
The thing is, like, the process continued with them as a continuous landlord, and we being a tenant. Reason being, dismantling of machines would diminish the value of the machines. If it is not properly done, then you will not fetch a proper return on the sale of those machines, or you will not get a proper plan. But
yeah, also normally it is also understood that the way factory was running, the way the premises was being used, that would continue, because that is also something which signifies going concern. Many people or many employees of the company who were working with the company might be living close to that place where they are, where there was a factory, where they were the tenancy, the rights were there for the company to function out of those premises. But what I'm trying to say is making payment for the rent or the obligations during the CRP period will be critical for the same.
And in continuation to that, if the CRP fails, there is no resolution plan coming in.
Okay. So in case the resolution plan fails or resolution plan does not come in and the company enters liquidation, there again where there is a possibility of sale as a going concern, there the tenancy can still continue, because the tenancy will have a right, or the acquirer can have a right over the tenancy that can continue in case it is a sale as a going concern, or business as a going concern, or entity as a going concern. Now, where you are saying selling assets on a piecemeal basis, it would not be possible, or normally the lease or the tenancy is not transferable as per the agreements in writing, and therefore you may not be able to sell the tenancy rights to somebody else. So, tenancy rights can certainly be transferred as part of a going concern transfer.
Absolutely. The issue when that crops up actually was there is one provision under the liquidation process regulations which say any continuation of the rent, if it is continuing, that is to be stopped from the liquidation process the day liquidation starts. So
but it is subject to that is also applicable to all the employees, but then there is a clause which says that in case the company is being maintained as a going concern, then it will not happen.
Well, yeah, but the liquidation order itself says the employees get discharged on the day a liquidation is ordered.
But so then the act is very clear on it that the employees will not be discharged in case the employees are retained, because the company is intended to be run as a going concern, and that decision is of the liquidator to take.
So, but the provision of not paying the rent under the liquidation process, if the company is not a going concern in that case, So that is
Yeah,
also
that can be that option is there, but then when you say that okay, I will no longer pay rent, and you have machines which are there, you would normally say that okay, because you're still having or using the place where the machines are kept, and you're not giving a vacant possession to the tenant, you would normally give them the same rent and maybe continue the tenancy,
right.
or maybe even renegotiate the rent if possible. That's also something that is within your powers.
Right. So we can also deny the rent as per the provision, going with the provisions then.
Not deny, I'm saying that we can fix a lower rent, we can negotiate with the landlord, fix a lower rent, but denying the rent may not be possible because the rent for the CRP period, the liquidation period, is part of the CRP cost or the liquidation cost, because you're incurring those expenses to protect your assets.
Yeah, to protect the assets. But at the same time, it says, no, liquidation says that continuing expenses in regard to rent and certain further expenses, there are certain expenses which is to be stopped, should not be considered.
But as I said, it needs to be stopped. But then, as I said, it is dependent on whether, if we are saying that, okay, well, let's assume that there is no going concern, and then there are other expenses which need to be stopped. Let's try and understand where that is in the regulation and try to take that out. Just a second. Do you remember which regulation was this in, or which section was this in?
Regulation 27, I believe.
27 is periodic payments. So it says, in case of rent, interest and such other payments of a periodical nature, a person may claim only for an amount due and unpaid up to the liquidation commencement date. Yes, you're correct. So this is something that is there. So the rent gets terminated, and after that it can continue only in case it is required to keep the assets safe, because in case the assets cannot be picked up from the place where these payments are ending, then it cannot be taken forward.
Understood, but the assets are there because we need to sell it on a piecemeal basis. And if we dismantle it, then we will not fetch the proper value. So that need to be put in there only and continue with this. At the same time, stopping the rent because of the liquidation process started under this regulation particularly.
Yeah, under this regulation, the periodic payments stop, and the rent, interest, and any other payments of a periodic nature are required to stop on the liquidation commencement date. But how long can you keep the premises of the landlord without paying rent is a big question then. Because in case you're not paying, so in case your liquidation process takes 1 year, then how will you balance that out? How will you take care of that? That's the big issue that needs to be taken care of. So I will see what if we at AAA Insolvency have any case where this tenancy has come in between, and maybe also prepare a note on how the tenancy or what can happen to the tenancy at various stages, and share it with Anu so that she can also share it with all of you. However, the case study at hand is more to do with SURFACE, and but we should definitely understand the implications with respect to tenancy rights in case of IBC.
Yeah, please, thanks.
Yeah. So over to you, Anu. I think we should be done with all questions. If there are any further questions, you're free to ask. Else, we will move on to the next speaker then. Over to Anu.
Yeah, if anybody has any question, they may ask. Thank you so much, sir, for the session. It was very informative and interactive. Thank you, sir. So now the next session will be taken by Nilesh, sir. Let me provide you a brief introduction of Nilesh, sir. Nilesh, sir, is a chartered accountant and a graduate in law. He is practicing as an insolvency professional since the commencement of Insolvency and Bankruptcy Code 2016. He is a partner in RRR Insolvency Service Experts LLP and RRR Legal Advisors LLP. He is practicing in the area of restructuring and insolvency for over 25 years. He has been representing his clients before different benches of NCLT and NCLAT on regular basis. He is a member of Insol India. He was rated as one of the leading lawyers in the field of restructuring and insolvency by various reputed international journals like Legal 500, Chambers and Partners, Asia Law Profiles, etc. for many years in a row. He is a regular speaker at various seminars on various topics on Insolvency and Bankruptcy Code 2016. So you may now start the session.
Okay, thank you, Anu. And very wonderful session by Ankit Goel. Ankit, congratulations. It was actually very, very informative. And I think most of us must have been immensely benefited because
Thank you, Nilesh ji. Thank you so much.
Thanks. Achha, so now I have prepared one PPT relating to this another judgment, which is Maitreya Doshi versus Anand Rathi Global Finance Limited. So let me share that PPT with you. Hope it is reflecting on your screen.
Yes, sir.
Okay. Yes. So this particular judgment is Maitreya Doshi appellant versus Anand Rathi Global Finance Limited and another. So in this particular case, Anand Rathi Global Finance Limited was the financial creditor, and Maitreya Doshi was actually the director in two entities, and those two entities were co-borrowers. Okay, so let's see what are the facts in this particular case, and then what is the what have been the arguments which were made by the different parties, and based on the same, what is the judgment of Honorable Supreme Court. Okay, so three parties in this case: appellant Maitreya Doshi, who is director of corporate debtor, rather directors of both the entities. Anand Rathi Global Finance Limited was the financial creditor, and Doshi Holding Private Limited was the co-borrower, and the main principal borrower was Premier Limited. So Premier Limited obtained loan from Anand Rathi Global Finance Limited, and the Doshi Holdings. Doshi Holding provided security of the shares which Doshi Holding was having in Premier Limited, so that those shares were placed with Anand Rathi for the loan which was provided to Premier Limited. Okay, and then Doshi Holdings and Premier Limited, both of them were co-borrowers in the loan documents which were executed. Okay, so let's see the facts of the case in brief. Anand Rathi Global Finance Limited. So I will read these, and then simultaneously we will be making discussions. NBFC, this particular NBFC, they disbursed loan amounting to rupees 6 crore to Messrs Premier Limited, referred to as Premier in this, under three separate loan cum pledge agreements, and dated 29 June 15, 4th May 16 and 5th October 16 respectively. Doshi Holdings Limited pledged shares held by it in Premier in favor of the financial creditor by way of security for the loan. Okay, so Doshi Holding was the pledger. At the same time, Premier Limited and Doshi Holdings, both of them were the co-borrowers in the loan documents, all the loan documents. Contemplated two different transactions. The loan cum pledge agreements contemplated two distinct transactions under one document, that is grant of loan to Premier and creation of pledge by Doshi Holdings. So actually two transactions were there, one for provision of debt, and another is for pledge of shares by Doshi Holding of security held by it in Premier. Then Premier defaulted in making repayment, and as a result, financial creditor demanded the money, which was 7 crore 64 lakh from Premier Limited on various dates. So that was in June 19 and then February 2020. Then 14th February 2020, the financial creditor called upon. So recall notice was issued to Premier as well as Doshi Holding, also described as the borrower under loan-cum-pledge agreement to pay the entire outstanding. Then by a letter dated 19th February, 5 days after this, Premier admitted and acknowledges its debt, its liability to pay, and then sought some time period, and it stated that it has not been able to make the payment due to some difficulty. Okay, so till 19th February 2020, this was the situation. Thereafter, on 21st September 2020, the financial creditor filed a petition under Section 7 of IBC against Premier as well as against Doshi Holding. Okay, so these two applications were filed by the FC against these two borrowers, against these two corporate debtors, two separate applications under Section 7. Then, so one of these application was admitted by Honorable NCLT, which was Mumbai, NCLT Mumbai, wide order dated 29 January 2021. And another application was admitted by Honorable NCLT on 19th February 2021. Okay, so both the applications were admitted by Honorable NCLT, and for the same set of loan, same amount of loan was there and same amount of default was there. I think you must be aware of one judgment of Honorable NCLT, wherein Honorable NCLT said, which is not part of this Honorable Supreme Court judgment. So Honorable NCLT initially said, I'm having those two judgments also. Let me go to that first, and then I will come back here again. So that Vishnu Kumar Agarwal versus Piramal Enterprises Limited. So you know that in this particular judgment, NCLT, the question before NCLT was whether for the same set of claims and default, insolvency proceedings can be initiated against the principal debtor and against the guarantor. So there the question was for the same set of default, same set of debt and default, can two insolvency proceedings be initiated? One against the debtor and against the guarantor, or against two guarantors. So therein, Honorable NCLT held that no, though you can file the application, but two applications cannot be admitted. Only one of them can be admitted. So first one which is admitted, so that will be admitted, but other one which is not admitted, that cannot be. Okay, so this was the view of Honorable NCLT. So for the same set of claim, once for same set of claim application under Section 7 filed by a financial creditor is admitted against one of the CD, second application by the same FC for same set of claim and default cannot be admitted against the other corporate debtor. So this was the ratio of that judgment. However, subsequently, and this was challenged before Honorable Supreme Court, and this appeal against this particular order of Honorable NCLT is still pending before Honorable Supreme Court. However, subsequently in this particular matter, State Bank of India versus Athena Energy Ventures Private Limited, same question arose, and then NCLT expressed the contrary view to the other the first judgment, Piramal judgment. So herein Honorable NCLT said that simultaneous initiation of CIRP against a CD and its guarantor is permissible. The Honorable NCLT further held that simultaneous remedy is central to a contract of guarantee, and where principal, borrower and surety are undergoing CIRP, the creditor should be able to file claims in CIRP of both of them. So not only that you can initiate, and not only that it can be admitted, you can file claims against both of them. So this was the ratio of the judgment of Honorable NCLT. Though appeal against this Piramal judgment, appeal against this Piramal Enterprises judgment is still pending before Honorable Supreme Court. However, NCLT expressed a totally contrary view. And that is the view I think all of us must agree, that you can proceed against the principal debtor, and also against the guarantor. You can proceed against the principal debtor first, or you can proceed against the guarantor first, or you can proceed against both of them simultaneously. So it is not necessary in case of a guarantor that first you have to proceed, first you have to exhaust your remedies against the principal debtor, and then only you can proceed against the guarantor. So no, it is not the case. You can proceed against the guarantor first, and then you can proceed against principal debtor, or you can proceed against them simultaneously. So any of these things are possible. So this is a well settled thing now. So let me go back to the to our facts of the case of that particular this one. So both the applications which were filed against Premier as well as this Doshi Holding, both of them were admitted. However, on 20, you will see that on 29 January 2021, adjudicating admitted the petition for initiation of CRP against Premier. And then after approximately 20 days, on 19th February, the application was admitted against Doshi Holding. However, in 29 January order, adjudicating authority mentioned that for the same amount of debt and default, the application cannot be admitted in respect of two corporate debtors. So this was the observation therein. So let's proceed further. The order was challenged by before Honorable NCLAT. The same appellant filed an appeal in NCLAT under Section 61, and by the impugned judgment and order dated, so Honorable NCLAT decided this appeal, wide order dated 25th August 2021, and they did not find any merits, and they dismissed the appeal and upheld the order of admission of the petition under Section 7. So this was the appeal against admission order, which was dated 19th of February 21 against Doshi Holding. So this order was challenged before Honorable NCLAT, and Honorable NCLAT did not find any merits, and then dismissed the appeal. And this order of NCLAT was challenged before Honorable Supreme Court. Okay, so now we come to the proceedings before Honorable Supreme Court. So now, what were the arguments which were taken by the appellant? Appellant is Doshi, that lady Maitreya Doshi, representing this particular creditor, which is Doshi Holding. So then Mr. KV Vishwanathan, senior counsel, his arguments were that no amount under the loan cum pledge agreements was disbursed by the financial creditors to Doshi Holding. Okay, so, and both these applications were admitted under Section 7. So question which was raised by the learned counsel for appellant, he stated that actually there is no disbursement to the financial creditor by the financial creditor to Doshi Holding. So under Section 5(8), the prerequisite is that a debt can be treated as a financial debt only when there is a disbursement. So now disbursement, he said that disbursement is not given to me. Disbursement is not given to Doshi Holding. So Doshi Holding cannot be treated as a financial creditor. Disbursement was to the other entity, Premier. So for Premier, the creditor can be a financial creditor, but not to me. To me, he can be an ordinary creditor. Then financial creditor granted loans to Premier. The loans were disbursed to Premier. Doshi Holding did not utilize any part of the money disbursed by the FC under the loan cum pledge agreement. So he said, I have not received any money. So how can he be my financial creditor? Then the loan cum pledge agreements were standard form agreements in which Premier was the borrower and Doshi Holding as the pledgor. Okay, so as we discussed that Doshi Holding was co-borrower also, and then he was a pledger also, because Doshi Holding pledges its shareholding in Premier in favor of the creditor. So he was having, so their argument was that Premier was the borrower as per the loan agreement, and Doshi Holding was only the pledger. Okay. For convenience, the borrower and the pledger have collectively been referred to as borrowers and individually referred to as borrower or pledger. So he said that in the loan agreements, borrower and the pledger, they collectively they have been referred to as borrowers. Okay, and individually they were referred to as borrower or pledger. So I cannot be treated as a borrower only because in the loan document you are collectively you are referring us as borrowers. So he said I was only a pledger. Then appellant executed the loan cum pledge agreement and other related documents on behalf of Premier. So Maitreya Doshi, she was authorized by both the companies actually for execution of loan agreements. So one Premier and then the Doshi Holding. So both of them, they executed loan cum pledge agreement and other related documents on behalf of Premier and Doshi Holdings, because the appellant had independently and separately been authorized by Premier and Doshi Holdings to execute the documents. The fact remains that Doshi Holding and Premier are separate entities. Okay, so this was further argument. Then no disbursement has been made to Doshi Holdings against consideration for the time value of money. There was no obligation on the part of Doshi Holding to make any repayment to the financial creditor. He said my shares were pledged in case of default and I have not even guaranteed it. I am not even a guarantor. So Doshi Holding only pledged the shares, and the documents provided that in case of default, the creditor is entitled to sell my shares, my shareholding. Okay, so I was not a borrower. Then there was therefore no financial debt owed by Doshi Holdings to the FC under section 5(8) of the IBC. Insofar as Doshi Holding is concerned, the loan cum pledge agreements only created a pledge of the shares of Doshi Holdings in Premier in favor of the FC. The petition under section 7 of IBC against the CD was clearly not maintainable. Okay, so they said that you are not by FC, so you can't file application under section 7. Then in support of his argument, Mr. Vishwanathan cited Anuj Jain in IRP for JP Infratech Limited versus Axis Bank Limited and others. So I think all of us are aware about this particular judgment. And in this particular judgment, I think you know the facts that JP Infratech Limited was the corporate debtor, and JP Associates Limited was the holding company of this JP Infra. Holding company JP Associates Limited had raised some loans from some of the lenders, and for that those loans JP Infratech mortgaged the land owned by it. Okay, and there was no guarantee agreement also. So in that particular matter, JP Infra, which we can refer to as JIL, and JIL's land was pledged in favor of financial creditors of JAL. Okay, so then issue arose, and then the financial creditors of JAL, they filed the claim in the insolvency of JIL, claiming themselves to be the financial creditors. Okay, so this question arose before Honorable Supreme Court as to whether, when there is no disbursement to JP Infratech Limited, whether they can be treated as those creditors can be treated as financial creditors of JIL. Okay, any view on this? Whether in this particular situation, the creditors of JIL, they should be treated as, whether they should be treated as financial creditors of JIL? I think you are aware of this judgment. Any view whether they should be treated as financial creditors or not? No? Okay. So Honorable Supreme Court in this particular matter said, and in this judgment which we are discussing today, so this this part, this section, this clause or para 46 has been reproduced. And this is essential element of dispersal, and that too against the consideration for time value of money, needs to be found in the genesis of any debt before it may be treated as financial debt within the meaning of section 5(8) of the code. Okay, let me take you to section 5(8), though it is not part of the judgment of this Maitreya Doshi judgment. But let me, I think you will be able to better understand this if we see the provisions of section 5(8). So see here, financial debt means a debt along with interest, if any interest is there, then only means a debt along with interest, if any, which is dispersed against the consideration for the time value of money and includes. Okay, so here we are having the definition which is given. You know that definitions are of two kinds, three kinds. One is where the word means is written. So financial debt means. Okay, so here one is that financial debt means. So meaning of financial debt has been defined, and then it says and includes. So including, and whenever the words the word include is there, that means the definition is inclusive. And when the word means is there, or means is there, that means that is exhaustive. So here, and this is third kind of definition where both the words have been used. So financial debt means the meaning of the same is that financial debt should comprise of only this. And when the word include is there, that means that these are some of the instances given. There can be other instances also. There can be other transactions of similar nature which can fall within the definition. Okay, so here the definition which has been used is financial debt means. So whatever is written against that or after that, that is the definition of financial debt. And then it says includes. Includes means these are given, some instances have been cited. Okay, now means a debt along with interest, if any, which is disbursed against the consideration for the time value of money. So this is the prerequisite. This is the true definition of financial debt. And includes, these are the instances, with A, B, C, D, etc. These are the instances. Okay, and Honorable Supreme Court in this particular matter said that even these subsequent clauses, they must satisfy this particular condition. What is that condition? A debt which is disbursed against the consideration for the time value of money, and then only they will be treated as part of financial debt. If any of the items which are written there in clauses A to I think I, if they don't have this element, then the debt cannot be considered. That cannot be treated as a financial debt. Now let's see. So this was main part of the definition, and then after that it says and includes. Let's see what are the items which are there under inclusive part of the definition. A, and kindly observe another important thing here. We have to see whether the money has been disbursed in these transactions which are listed after in the second part of this definition. So whether in these transactions money is disbursed to the corporate debtor or to somebody else. So that we have to minutely observe. One, money borrowed against the payment of interest. Okay, so money borrowed by whom? So naturally, money borrowed against the payment of interest, they are referring to the debtor. If money is borrowed by somebody else, okay, so then I cannot be the debtor in that particular case, or the creditor cannot be treated as financial creditor of me if money is borrowed by somebody else. So money borrowed against the payment of interest, this is one. Any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent. Here also, who has raised the money? Any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent. Okay, so acceptance credit facilities. So in that particular case also, the money which has been borrowed by the debtor, if it is borrowed by somebody else, I don't think it will fall within this. Here they are referring to the amount raised by the debtor, our particular debtor, and money is raised by him only. Any amount raised pursuant to any note purchase facility or the issue of bonds, notes, debentures, loan stock, or any similar instrument. So here also, if any debt has been raised by issuance of any, by pursuant to any note purchase facility, or when bonds have been issued, so bonds have been issued by the corporate debtor, then only, na? Otherwise, if bonds are issued by somebody else, I don't think this is referring to a situation where bonds have been issued by somebody else. Then amount of any liability in respect of any lease or HP contract. So I don't think you are having any doubt that where any lease or hire purchase contract, that is also a way of getting the finance from a financial creditor. So what we do in that case is that we lease or hire purchase contract. So actually these are the kinds of financing transactions. So where actually this is not the operating lease. So lease or hire purchase agreement, which is deemed as a finance or capital lease under the Indian accounting standard or such other accounting standard as may be prescribed. So here finance lease or capital lease. So these are also to be treated as this one. Receivables sold or discounted other than any receivables sold on non-recourse basis. So you are aware that receivables sold. So this is also a kind of financing transaction where you sell your receivables, and in case recovery is not made by the bank, okay, so then bank can come back to you. So it is not on non-recourse basis. It is on recourse basis. If there is any default, then bank can come back to you. So in that situation also, transaction is, if it is sold permanently without any if it is on non-recourse basis, then it is a sale. It is not a financial transaction. Then amount raised under any other transaction, including any forward sale or purchase agreement. So you know that I am selling something and then I am having an agreement for purchasing, buying that back after a period of 1 year, 1.5 years. So that is also a kind of funding arrangement, so having the commercial effect of a borrowing. So where this type of transaction is there, that will also be treated as financial debt. So this was the explanation which was added subsequently in 2000 Act, subsequently only, I think. I'm not sure whether in 2018. So in that particular, at that particular part of time, these real estate transactions were also included through this explanation. Any derivative transaction entered into in connection with protection against or benefit from fluctuation in any rate. So these are derivative transactions. They fall within the ambit of financial transaction. There is no doubt about that. H and I, they are very important. Any counter indemnity obligation in respect of a guarantee, indemnity, bond, documentary, LC, or any other instrument issued by a bank or financial institution. So here, you know that we go to the banker, we request the banker that you issue a bank guarantee in favor of a third party on my behalf. And then bank says, okay, you give me counter indemnity obligation that in case there is a default, then you will be making payment. So the counter indemnity obligation, okay, is in respect of what? In respect of bank guarantee which is being issued on my behalf. So I am availing that benefit. Okay, so here guarantee is issued by bank on my behalf, and in case there is any default, so payment is made by the bank on my behalf to a third party. Then only it becomes payable, it becomes recoverable from me. Okay, so the counter indemnity obligation issued by me. Okay, so it is also in respect of a guarantee or document or LC or etc., which is where finance is provided to me or on my behalf. Okay, so it is not here. It is not it is not a guarantee which is issued by me. It is a guarantee issued by a banker on my behalf. Then amount of any liability in respect of any of the guarantee or indemnity for any of the items referred to in subclauses A to H of this clause. So here, the amount of in respect of guarantee or indemnity for any of the items referred to in subclauses A to H of this clause. So A to H are what? A to H, these clauses are where the CD, this particular CD is taking disbursement. Okay, and for taking that disbursement, when he is taking the amount of liability, if because of that disbursement there is any liability arises in respect of any of the guarantee or indemnity for any of the items referred to in this one. So A to H is only when when disbursement is made to me, and for that purpose, if any guarantee has been issued, okay, so then that will be treated as, that will be falling under this thing. So disbursement to me, guarantee is given by whom? Then in that case, guarantee will be given by a third party. Okay, so this is, so guarantee is covered here in this particular case, because if for my debt, it is my debt, I have taken the disbursement and guarantee has been given by a third party. So then in that case, it will fall within the ambit of this one. Now, let's go back. Sorry. So in this particular case, financial debt, they said that even Supreme Court, Honorable Supreme Court, in this particular case said that the first part of the definition, the first requirement, and what is that first requirement? Which is that the money should be disbursed against the consideration for the time value of money. And to whom? To the debtor, to our corporate debtor. Okay, so that is a prerequisite. And if the other clauses, they don't result in any disbursement of money to the corporate debtor, then FC cannot be the FC of my FC. Okay, so essential element of dispersal and that too against the consideration for time value of money needs to be found in the genesis of any debt before it may be treated as financial debt within the meaning of section 5(8) of the code. Now, further. Arguments of appellants are continuing here. It was argued that the adjudicating authority, appellate authority, erred in arriving at the finding that Doshi Holding was a borrower and hence liable to make repayment in respect of the loan disbursed to Premier. He submitted that the loan was never utilized by Doshi Holding. So again, the same argument that no part of the loan was ever, there was no disbursement to Doshi Holding, there was no no utilization by Doshi Holding of the loan which was disbursed. It was not in dispute that no amount was disbursed to Doshi Holding. Having accepted the factual position that no amount had been disbursed to Doshi Holding, AA or appellate authority erred in arriving at the finding that Doshi Holding was a borrower. So they said that if I have not received any money, so you can't treat me as a borrower. The petition under section 7 of IBC was not maintainable against Doshi Holding. So two arguments here. One, that I have not received any money, and so I am not a borrower. Second, if I have not received the money, then I can't be a financial debtor, or that creditor cannot be treated as a financial creditor. So application cannot be made under section 7. Then adjudicating authority misconstrued the expression financial debt in section 5(8) and failed to appreciate the scope and ambit of the said expression. Definition of financial debt does not include a pledge. Contract of indemnity, guarantee and pledge have been defined in the Indian Contract Act. The expressions are different from one and another in terms of their ramification and implication, and they cannot be equated. Distinguishing between the expression contract of indemnity and contract of guarantee and pledge. That creation of pledge of share by the CD did not and cannot amount to a guarantee and or indemnity. Okay, under section 5(8). So he said the pledging of share, I am not a borrower. Now consider that if I am a pledgee, if I am a pledger, so whether I can be considered. So they said that no, because 5(8) covers under certain circumstances, this guarantee and indemnity transactions, but not the transaction of a pledge. So this was another judgment form which was cited by appellant. Phoenix ARC versus Ketul Bhai Ramu Bhai Patel. And in this matter, you are aware that Honorable Supreme Court, relying upon Anuj Jain matter, held that a CD had only extended security by pledging shares. The applicant would at best be the secured debtor qua security, but not a financial creditor within the secured creditor, not secured debtor. So in this particular matter, Honorable Supreme Court said that when if a corporate debtor has extended security by pledging of shares, okay, so then the creditor cannot be treated as a financial creditor. At the most, it can be treated as a secured creditor, not the secured financial creditor. Secured creditor because it is holding the security. So secured creditor it can be treated as, but not the financial creditor. This was the judgment of Honorable Supreme Court. So this was cited by the appellants. Adjudicating authority interchangeably refer to Doshi holding as a co-borrower or guarantor under the non-cum pledge agreement, losing sight of the difference in the liability of a pledger from that of a guarantor. So they said their adjudicating authority has used the word guarantor. I'm not a guarantor. And they have used the word co-borrower against me. I'm not a co-borrower also. They said that I am only a pledger. Appellate authority failed to appreciate that execution of a promissory note. So this was another argument which had been taken before NCLAT also, that this party, Doshi Holding, issued a promissory note. Okay, and promissory note in favor of the financial creditor. So plea was taken that if it is not a borrower, then why it has issued promissory note? So issuance of a promissory note proves that this Doshi Holding is a borrower. Okay, so to this, the argument taken by appellant was that appellate authority failed to appreciate that the execution of a promissory note gives rise to a presumption that such promissory note is supported by consideration. The presumption is, however, rebuttable. So they said that there can only be presumption that there is a consideration, but that actually there is no consideration. I have not received anything when I have issued a promissory note. So that does not mean that is final that I am a borrower. If I can prove, the presumption that I am a borrower, that can be rebutted. So I can rebut that assumption. Adjudicating authority interchangeably refer to Doshi Holding as a guarantor, losing sight of the difference in the liability. So this is the same argument again. Appellant cited Bharat Barrel and Drum Manufacturing Company Limited, where this court, they said that the same issue relating to promissory note, that issuance of a promissory note, then it says the presumption there is that it is supported by consideration, but that consideration is rebuttable. So this judgment was referred to in that connection. Premier were collectively referred to as the borrowers and individually we have already discussed. Finally argued, adjudicating authority had passed its order dated 19th February 21, impugned in this appeal, ignoring its earlier finding pronounced in open court on 29th January, stating, under Section 7, if the claim against Premier Limited is admitted, then for the same set of loans arising under the same loan document, the same debt claim against Doshi will not be permissible. So this was the finding, or this was the recording of Honorable NCLT in the matter of Premier Limited. When Premier Limited admission was made, then NCLT made this this clause was there in the order. This was the finding of the this one, or they held that for the same set of loans, the against Doshi, the application cannot be admitted. However, that that subsequently on 19th of February, NCLT admitted. Though on 29 January, NCLT said that no, it cannot be admitted. So in this connection, the argument which was taken was that order of admission was contrary to judicial discipline. Relying on the judgment of this court in Sub-Inspector Ruplal and another, that in the event, if any member of the bench was of the opinion that earlier view taken by another member of the same bench was incorrect, the matter should have been referred to a larger bench to avoid difference of opinion. So they said that NCLT was bound by its earlier view. If they wrote in the minutes, in the order, that for the same set of debt and default, the admission cannot be made against this one, another party, which is Doshi Holding. So they are bound by the same. If they were having a different view, then they should have requested for constitution of a larger bench. However, this was not done. So these were the arguments by the appellant. Now see what were the arguments by the respondent, which is financial creditor. So Pratik Sakseria, learned counsel appearing on behalf of the respondent, submitted that Doshi Holding was party to the loan-cum-pledge agreement in its dual capacity as co-borrower and pledger, which had pledged a share in Premier in favor of the FC. Okay, so two capacities were there. So Doshi Holding was also a borrower and not only a pledger. Fact emphasized was that the appellant had signed documents on behalf of Doshi Holding in its capacity as a co-borrower. Then following documents were referred to, that in all these documents he has been referred, that entity has been referred to as co-borrower. Both Premier and Doshi Holdings have been described as borrower in the loan-cum-pledge agreements. Also, Doshi Holding had acknowledged receipt of money disbursed under 3 loan agreements by executing loan receipts. Doshi Holdings had also issued demand promissory note. Okay, then loan agreement receipts and all the other documents have been signed by the appellant in his capacity as the authorized signatory director of Doshi Holding and Premier. After Premier defaulted in payment of loan, demand notice was issued to Doshi Holding to repay the loan in its capacity as a co-borrower. It was argued that definition of financial debt contemplates a disbursement against consideration for time value of money and not a dispersal necessary to the corporate debtor. Otherwise, an amount payable under a guarantee could never have been included in as much as amounts are never disbursed to a guarantor, but he is liable for debts of another. So now question is that they said that there is a requirement that disbursal has to be there against consideration for time value of money. But section does not say that the disbursement has to be to the corporate debtor only. Okay, so disbursement can be to a third party also. Okay, so even in that case, and you are a borrower or you are a guarantor, then you will be the creditor will be treated as a financial creditor towards you. Definition of CD does not require as a precondition that money should have been disbursed to the CD. The sine qua non for an entity to be considered as a CD is that such person or entity should have owe a debt to any person, and not that a disbursal has to be made to such a person or the entity. So they say that he should be a debtor, he should be a borrower. It is not necessary that the disbursement has to be made to him only, and still he will be treated as Doshi Holding satisfies the aforesaid criteria in as much as it is a co-borrower in terms of loan agreement under which monies have been borrowed by both Premier and Doshi. Both the Premier and Doshi Holdings have executed loan receipt, admitting receipt of loans amount and demand promissory notes. Mere fact of it also being a pledger is wholly irrelevant. So he said that it was said that he is also a pledger, but that is not relevant for this purpose. He is a co-borrower also. Okay, and then after hearing these arguments, Honorable Supreme Court held that it is not in dispute that FC disbursed loan to the tune of ₹6 crore to Premier pursuant to the loan cum pledge agreements. referred to above executed both by Premier and Doshi Holdings. So loan was disbursed to Premier, but the loan documents were executed by Premier and Doshi Holding. Doshi Holding has been referred to in the agreement as borrower as well as pledger. Prima facie, it appears that Doshi Holding was a party to the loan cum pledge agreement in its dual capacity of borrower and pledger of shares. So it is not that the Doshi Holding was only a pledger, but Doshi Holding has been there as a co-borrower also. AA, appellate authority has arrived at the factual finding that Doshi Holding is also a borrower under the loan cum pledge agreement. So this was the finding of appellate authority, that Doshi Holding is a borrower under that agreement. Factual finding of appellate authority, which was the final fact finding authority, ought not to be interfered in this appeal. So as you are aware that under section 62, appeal can go to Honorable Supreme Court only on questions of law. Okay, on question of fact, you can't go to Honorable Supreme Court. And for questions of fact, who is the final authority? Final fact finding authority is appellate authority. So whatever fact has been decided, but whatever fact has been found by appellate authority, that is final. So that fact finding thing cannot be challenged before Honorable Supreme Court. So here Honorable Supreme Court said that this one appellate authority has decided or has arrived at the factual finding that Disha Holding is also a borrower under the loan cum pledge agreement, and I am not having the jurisdiction to go into this issue again, because appellate authority is the final fact finding authority. So Supreme Court said that Doshi Holding is also a borrower. There is no doubt about that. Finding of the appellate authority that Doshi Holding is a borrower is based on its interpretation of the loan cum pledge agreements and supporting documents. Interpretation given by is definitely a possible interpretation. In our view, the interpretation is a plausible interpretation which cannot be interfered with in an appeal under section 62 of IBC. It is true, as argued by Mr. Vishwanathan, that contract of indemnity, contract of guarantee and pledge are not one and the same. Contract of indemnity is a contract by which one party promises to save the other from loss caused to him by the conduct of promisor himself or by the conduct of any other person. In a contract of indemnity, a promisee acting within the scope of the authority is entitled to recover from the promisor all damages and all costs which he may incur. Findings of the appellate authority that Doshi Holding is a borrower is based on its interpretation of the loan cum pledge agreements and supporting documents. A contract of guarantee, on the other hand, is a promise where the promisor promises to discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is the principal debtor, and the person to whom the guarantee is given is the creditor. So this was the Honorable Supreme Court said. Anything done or any promise made for the benefit of principal debtor may be a sufficient consideration to the surety for giving a guarantee. So we all know that guarantor does not get a consideration. Okay, and or in other words, the loan which is being disbursed by the creditor to the debtor, that is sufficient consideration for the guarantor to give his guarantee. Okay, so Honorable Supreme Court said that it is not necessary that the consideration should be given, because the plea which was taken here was that the Doshi Holding did not receive any consideration. So Honorable Supreme Court that in a contract of guarantee, actually there is no consideration required. On the other hand, the bailment of goods as security for payment of debt or performance of a promise is a pledge. So when you are giving some goods as security for payment of a debt or performance, that is a pledge. The proposition of law which emerges from the judgment is that a pledger per se may not be a financial creditor, may not be a financial debtor. So if there is a transaction of pledge, okay, so the creditor does not become a financial creditor of the pledger. So this was Honorable Supreme Court held this in this particular judgment. However, in this case, as observed above, appellate authority arrived at a factual finding that Disha Holding was a borrower. So they said that not because of the fact that the pledge has been made, but because Disha Holding is a borrower. and that fact is final now. In Lalit Kumar Jain versus Union of India, this court held that the approval of a resolution plan in relation to a city does not discharge. So they said that if Disha Holding and then Premier, so you can proceed against both of them. It was held in Lalit Kumar Jain versus Union of India, so that if you are able to, if there is a resolution plan which is approved in case of one particular debtor, suppose Premier Limited, there is a plan which is approved. So that does not absolve or that does not discharge Disha Holding. That does not discharge the debt of another borrower or co-borrower. Okay, so the Honorable Supreme Court referred to Lalit Kumar Jain versus Union of India judgment also. Then, if there are two borrowers or if two corporate bodies fall within the ambit of corporate debtor, there is no reason why proceedings under Section 7 of the IBC cannot be initiated against both the corporate debtors. So actually, this particular matter is where two corporate debtors, two entities, they fall within the ambit of corporate debtors. That means they are co-borrowers, and it is not necessary that the money has to go to both of them. So even if money is going to one and another is also a borrower, is a co-borrower, then both of them are liable. And against both of them, Section 7 application can be initiated. That means the creditor will be treated as financial creditors of both of them. Needless to mention, the same amount cannot be realized. And then you know that. So if suppose I am filing Section 7 application against one principal debtor or two co-borrowers. So it is not that if suppose my debt is, for example, 100 crore. Okay, so against X, I filed I initiated Section 7. Against Y also, my claim will be 100 crore. So in both the cases, I cannot recover more than 100 crore. So my maximum amount I can recover is only 100. Okay, so needless to mention, the same amount cannot be realized from both the series. If the dues are realized in part from one CD, the balance may be realized from the other CD, being the co-borrower. However, once the claim of the FC is discharged, there can be no question of recovery of the claim twice over. The appeal was then dismissed by Honorable Supreme Court. Okay, so what is the ratio here? So ratio here has been that if two co-borrowers are there in a financial, in a transaction which falls within the ambit of financial, borrowers can be treated as corporate debtors, and the creditor will be treated as a financial creditor in both the cases, and Section 7 can be initiated and admitted against both of them. Okay, so this was the ratio. Another thing Honorable Supreme Court has stated herein is that if there is a pledge by one entity for the debt of another entity, so only because you have pledged your asset, then you don't become a financial debtor, or the creditor does not become your financial creditor. So these were the two ratios of this particular judgment. I think this we have already discussed. Anuj Jain was referred to here. I have already explained that to you. And then Vishnu Kumar Agarwal also I have I think discuss with you. So with this we can close, except that if you are having any questions, you can ask me questions. Otherwise, we close the session. Any questions, please?
Sir, I'm Praveen Damandar. One question: if the main holding company issues a letter of guarantee on behalf of the subsidiary company, then I think it will be financial debt because the letter of credit is covered in subsection H. Is my understanding correct?
Okay. Actually, if you see the judgment, so here I am having one issue with this particular judgment, and that is that the one borrower is not getting any disbursement, and Honorable Supreme Court has, in the matter of GP Infra, very clearly held that the first part of the definition has to be complied with by the transactions which are listed there. So if that first part is not getting met or not getting fulfilled, then there is no question of the debt being treated as a financial debt. So according to me, even guarantee transaction, though we are having some other matters also, I think we are having that judgment of this one, Lakshmipat Surana. So Lakshmipat Surana was also a matter of where guarantee was executed. Okay, but the issue that issue was not decided. It was not decided by Honorable Supreme Court in that matter that a guarantor, a guarantee holding creditor will be treated as a financial creditor of the surety of the financial creditor of the person who has given the guarantee or the guarantor. Okay, so there is a disconnect in these two judgments. One judgment here in this particular judgment, Honorable Supreme Court says because both of them are co-borrowers. But where is that element of disbursement to this? In that particular matter, JP Associates Limited, to JP Associates Limited, there was a disbursement. Okay, it is not that there was no disbursement. JP Associates, there was a disbursement, but there was no disbursement to JP Infra. So Honorable Supreme Court says that these creditors, these FCs to JP Associates cannot be treated as financial creditors of JP Infra because they have not disbursed the money to JP Infra. Okay, so then how come in this particular matter, in this particular judgment, Honorable Supreme Court say that though there is no disbursement to this particular Doshi holding, you still will be treated as a financial creditor. That financial creditor will be, the creditor will be treated as a financial creditor. So I think both these judgments, they are contrary. I think they are not based on the definition. This particular judgment actually, though it is referred, that particular judgment has been referred to by the appellant. But Honorable Supreme Court has given a view, expressed a view which is contrary to the earlier. So according to me, if we follow the judgment which has been given in the case of JP Infra, according to me, that if guarantee has been given by the corporate debtor, okay, for the debt of any other entity, then in that case, the creditor, the guarantee holder, will not be treated as a creditor, will not be treated as a financial creditor of this corporate debtor. Okay, Kaviji?
Okay, but then see, normally bank give the LC and they think that they are the financial creditor. But if you strictly interpret of this section, then
no, there is a difference. There is a difference. Here we are talking about the guarantee has been given by the corporate debtor for the debt of another company. So question is, because now money has gone to some other company, money has not come to the corporate debtor. So in that case, the creditor will not be treated as a financial creditor of this corporate debtor. I think that is my view based on JP Infra. Yes. Okay. Now question is that we have given, the other company has given a corporate guarantee, it has given a guarantee for the debt disbursed to me. My bankers, my lenders, they are holding the guarantee also. Guarantee also for my debt. So there is no question because they in any case are my financial creditor. Yes. So now question will be whether in the insolvency of that other entity who has given guarantee for me, in that case my lender cannot be treated as financial creditor. Okay.
Okay, fine.
Any other question? No. Shall we close then? Shall we close today's session then? Anu, are you there?
Yes, sir. If there are any questions that may be asked.
But sir, this will have wide repercussions. Every borrower or the lender has lent the money on the strength of that borrower or on the strength of the promoter. If this view is taken as final view, then the entire document is become, useless, and the IBC will not be able to, and the lender will not be able to use the IBC at all.
No, the lender will be treated as not as a financial creditor, but
then,
as an other creditor, lender.
But as a other creditor, okay, but then I will not be able to use IBC under Section 7.
No, not under Section 7. I don't think under Section 7 it can be done. And I think there is no form prescribed in respect of other financial creditor initiating the section.
And then Section 9(1) will say that it is not good supplied.
Section 9 also does not apply. I think a separate form will have
then
to.
Then IBC will not be used at all.
Definitely in this type of a situation. So I think what is required to be done is that separate form will have to be prescribed for other creditors to initiate insolvency CIRP process. Okay, then only they will be able to utilize.
But then there should be separate section also, no? Like 7, 9.
Definitely.
The code need to be amended then.
Totally agree with you. I totally agree with you. Because otherwise there is no only OCs they can file under Section 9, FCs they can file under Section 7, but other creditors I don't think there is any section prescribed or any form prescribed.
So it looks like day by day IBC is becoming less useful for the financial creditor. See, one side the Vidarbha is there, other side this Redbo is there. And now this Anand and Anand Rathi and Doshi judgment is there, which you have discussed. So,
Praveenji, whenever there is a new enactment, so you will see that this type of things happen, because now it is evolving. So every day new interpretations are there, and even in the acts which are very, very old, even then you will find that after notification of a particular act 20 years back, 25 years back, still new interpretations are there. So that process goes on. But at the same time, these are the anomalies actually. In that particular matter of Rainbow also there was an anomaly. Because I don't think it is a judgment which is not correct. That judgment is correct interpretation. But our preamble says that the priority is altered. But in the secured creditors, even the word secured creditor is there under Section 53. So there even statutory creditor will also fall. So I think that needs to be rectified by way of an amendment, and I expect that there should be some ordinance very soon to rectify that. Otherwise, I don't think we will be able to get any resolution plan approved based on this Rainbow judgment.
Correct, sir. Correct. Absolutely.
And then that other judgment also, wherein they say that there also, I think something needs to be done. Otherwise, no case will be admitted. No case under Section 7 will be admitted, because in all the cases, pleas will be that consider all the circumstances, and after you consider all the circumstances, you consider viability. This should not be accepted. Section 7 should not be admitted. So that definitely is a problem.
Okay, right. Sir. Thanks a lot. Thanks a lot, sir.
Okay, thank you.
Thank you, sir, for taking the session. It was a very detailed presentation. Thank you for helping us understand the case in detail. And thank you so much. Thank you to all the participants as well for taking the session.
Thank you very much, everybody.
Thanks. Thanks, ICISI also.
Thank you.
And thanks, Madam Sharma.